Mr. Stevens.
My Lord, thank you. My Lord, just before the lunch adjournment, I'd said, I think, what I wanted to say about the case of Thomas and Baptiste, and there was just one more authority that I wanted to show you, if I may. Again, a local authority and slightly more recent, and that is the State of Trinidad and Tobago and Boyce, which is at 2531 of your Lordship's bundle. It's a decision of the board, and it concerned a new right of appeal which was given to the prosecution against a judgment or verdict of acquittal of a trial court. My lords don't need, I think, to know any more about it than that before turning to the passage that I'd like you to look at in the judgment of Lord Hoffman at 2541. That's 2541, and it's numbered paragraphs 13 and 14 of the judgment. Starting in the fourth line, in one sense, to say that an accused person is entitled to due process of law means that he's entitled to be tried according to law. In this sense, the concept of due process incorporates observance of all the mandatory requirements of criminal procedure, whatever they may be. If unanimity is required for a verdict of a jury, a conviction by a majority would not be in accordance with due process of law. If the accused is entitled to raise a defense of alibi without any prior notice, a conviction after the judge directed the jury to ignore such a defense because it had not been mentioned until the accused made a statement from the dock would not be in accordance with due process of law. But due process of law also has a narrower constitutional meaning, namely those fundamental principles which are necessary for a fair system of justice. That is a fundamental principle. Thus, it is a fundamental principle that the accused should be heard in his own defense and be entitled to call witnesses, but that does not mean that he should necessarily be entitled to raise an alibi or call alibi witnesses without having given prior notice to the prosecution. The change in the law which requires him to give such notice is a change in what would count as due process of law in the broader sense. It does not, however, mean that he has been deprived of his constitutional right to due process of law in the narrower sense. Lord Millet made this point in Thomas and Baptiste when he said that the term due process in the Constitution does not refer to any particular laws and is not a synonym for common law or statute. Rather, it invokes the concept of the rule of law itself and the universally accepted standards of justice observed by civilized nations which observe the rule of law. It does not guarantee the particular forms of legal procedure existing when the Constitution came into force. The content of the clause is not immutably fixed at that date. My lords, insofar as it invokes the rule of law, it does so in as much as procedural fairness is an aspect of the rule of law, in the sense that Lord Leggett put to my learned friend when he suggested, among other things, that it encapsulated the fundamental standards of justice. Now, my lords, that is the last of the cases that I wanted to show you. In the cases of breaches of due process in the wider non-constitutional sense mentioned by Lord Hoffman, of course, the remedy is by way of appeal or sometimes judicial review, not under the Constitution. And it's only when it is understood, when it's the case that a breach of due process in the narrow sense, that there is constitutional remedy. My lords, I submit that when due process is understood in the way in which it is explained in the various cases which I have shown you, there can be no question whatsoever that the appellant's detention, otherwise than in a community residence, breached, to use Lord Hoffman's words, any of the fundamental principles which are necessary for a fair system of justice. Thus, according to the Court of Appeal, my lords, I'm looking at 1235, paragraph 111 of the judgment. the magistrate constituted an independent and impartial tribunal from whose decision there was a route of redress. Secondly, there was nothing arbitrary about the detention of the appellants. Their detention was mandatory, and one finds that at page 1230 in paragraph 103 and in paragraphs 110 and 112 at respectively 1235 and 1236. Thirdly, as I've already submitted, there was no allegation of any breach of natural justice. That's also at 1236, paragraph 112, nor, as I've submitted, any of the other provisions at A to H of section 5.2, and nor did the compliance with section 54.1, non-compliance, forgive me, with section 54.1 and 61 of the Children Act amount to a breach of due process in the constitutional sense of the term, as explained by Lord Hoffman in Boyce, and that's at page 1237, paragraph 115. So in short, my lords, having abandoned their separate and specific section 5.2b challenge, alleging cruel and unusual treatment, the appellants are unable to identify any breach in my submission of section 4a. And in particular, as I've submitted, the failure to detain them in a community residence did not breach any of the fundamental, and I underline that word, fundamental principles which are necessary for a fair system of justice. Rather, my lords, the failure of the state to establish a suitable community residence in which they could be detained was an omission in the nature of an administrative failure. A significant one, I accept, but that is what it was. And the resultant order of the magistrate was amenable to judicial review. And indeed, orders for interim relief were granted in each case. And I'm going to show you those because Sir Bernard asked about that, and in particular, I think in relation to Brian. So I thought it might be helpful if I just took you through the interim relief that was in fact ordered in each case so that you can see what happened. Can I first, though, just, well, no, my lords, I'll do that first. Can we start with Sasha, please, who's a little easier. It's a less complicated story. She sought interim relief and her application came before Rampersad J. And Mr. Justice Rampersad found that he could not grant interim relief. If you look at page 2698, the bundle, which is in the judgment of Justice Rampersad, starting at paragraph 38, I don't propose to read all of this, but to give you the flavour of it, to remedy the situation would call for positive steps and direct orders mandating action on the part of the state. And then there's a discussion of the power of the court to do that. If you then cast your eye across to 41, with respect to the undertaking sought in the alternative that a suitable community residence approved by the Children's Authority be established immediately, in effect imposes a mandatory injunction on the state to take these steps. And then at 42, having discussed that, consequently, the application for the conservatory order made as part of the notice of application is refused. And that's because he concluded that he didn't have the power to make such a mandatory order. From that decision, there was an appeal to the Court of Appeal. The judgment of the Court of Appeal is at page 2701 and following of the bundle. And if I could ask you to look at page 2728, at paragraph 67, the Court of Appeal held that in any event, because this action is a mixed proceeding, injunctive interim relief could have been granted pursuant to Section 8 of the Judicial Review Act. Further, an interim declaration remains a theoretical possibility under Section 22 of the State Liability and Proceedings Act. There was a nice question that needn't trouble your lordships below in Sasha's case in particular as to whether or not a mandatory order could be made against the state. But as I say, I don't think your lordships need to concern yourselves with that. If you then look at paragraph 68, thus, insofar as the judge concluded that he lacked the jurisdiction to make any interim orders other than a Bansraj type conservatory order, he was plainly wrong. He had the jurisdiction to do so in this case by virtue of Section 8 of the Judicial Review Act and also pursuant to Section 14 of the Constitution. The latter obviously begged the question of whether or not constitutional rights were engaged, but on an interim basis, where it was conceded, I think, that there was a triable issue, it would have been permissible both under Section 8 and Section 14. If my lords then go to page 2730, so 2730, paragraph 75 for the conclusion of the Court of Appeal, it's in all these circumstances that this court formed the view that the most appropriate interim order was one that would have the effect of compelling the state to put things in place to give effect to the provisions of the law relating to the detention of minors on remand. In all the circumstances of this case, this would be in the best interest of the minor, and so on. And then the order appears at 2731, little one being the most pertinent, that the Attorney General do provide a suitable community residence as provided for in the children legislation on or before the 8th of December 2015, and then little 2 that upon provision of that residence she be transferred forthwith. Now, the matter didn't rest there because there was an appeal to the Judicial Committee, and that, my lords, you will find, by that I mean the judgment, you will find at 2728. Judgment given by Lady Hale at 2825 and following. My lords, perhaps I could just ask you to look first at paragraph 5. The matter was dealt with, that's 2826, forgive me. The matter was dealt with promptly by the courts in Trinidad and Tobago. On 2nd September 2015, Rampersad J granted leave to apply for judicial review. And then 4 lines from the bottom of that paragraph, on 28th September, Rampersad J refused the application for conservatory orders because 1 would put the court in breach of both the Bail Act and the Children Act, and 2 was not pursued by the appellant. Furthermore, 1 and 2 were mandatory rather conservatory. That's the judgment I showed you a moment ago of Mr. Justice Rampersad. Then, my lords, just briefly to note at paragraph 8, Lady Hale summarised the Court of Appeal's reasons. If I could just ask you to look at subparagraph 4, which is at 2828, simply for confirmation of the position in relation to the Judicial Review Act. Section 8 of the Judicial Review Act of Trinidad and Tobago expressly provides for the granting of injunctive relief against public authorities in administrative law actions. It would be quite an anomaly if an injunction could be obtained in administrative law actions, but not where there was an alleged breach of the rights under 4A and 4B. And then, my lords, moving to paragraph 13, to this, these were my submissions, my lords, to this the respondents point out that they had conceded that there was a prima facie case. There were serious issues to be tried. The courts would have to resolve not the contradiction between the Bail Act and Section 54 of the Children Act, but the friction between the Bail Act and the unavailability of a suitable community residence. The appellant was asking for an order for her release, contrary to the prohibition of bail. and then there's an observation that release to her mother would have been less satisfactory potentially, then the Bail Act was not being challenged as unconstitutional. The lack of a suitable community residence did not and could not abrogate the prohibition of bail. There was an issue about whether the adult women's prison could be a community residence. There were very real issues as to whether breaches of her constitutional rights would indeed be established. The Court of Appeal was in a difficult position and was right to do what it did. Paragraph 14, the board is in no doubt that in this difficult situation, the Court of Appeal made the only order which it could have made. It was the order which best resolved the conflict between the Bail Act and the non-availability of a suitable community residence. The court concluded that it had power to make such an order after an impressive discussion of the relevant legislation and authorities, etc. And my lords, just to complete the picture, the statement of facts and issues at page 1850, in paragraph 10, as Sir Bernard has already observed, recites, among other things, that on the 7th of December 2015, the first appellant was moved to a community residence. That's the agreed fact. And until Mr. Clayton appeared to cast some doubt on that today, I thought, and I still think, that that is the position, my lords. But on that basis, that shows that Sasha's case was dealt with in the timescales which my lord Sir Bernard put to Mr. Clayton, and as the Privy Council suggested, promptly in the courts of Trinidad and Tobago. Moving then to Brian. It's perhaps worth just noting first his application for leave. If your lordships could look at page 645 of the bundle, you'll find that at paragraph 11 of his application, the interim relief he sought, and the only interim relief he sought, was a conservatory order directing the Attorney General to undertake that the Commissioner of Prisons will no longer detain him, and an order that the Commissioner forthwith release him into the custody of his mother. Now, Sasha had asked for that, but also in the alternative for a community residence to be provided. But that's what Brian asked for. The starting point in what is a slightly complicated series of hearings before Justice Corcoran is the judgment given on the application for permission, and that is at 2758. And in paragraph 24, which is at 2767, your lordships will see this. Under the heading Conservatory Order, just above paragraph 23, paragraph 24 reads, the parties have in fact advanced three options as an interim position. First, that as contended by senior counsel for the applicant, in the absence of any licensed community residence, the child be released in the custody of his mother. Second, that as submitted by attorney for the respondents, the child remains at the youth training centre with suitable undertakings and conditions provided for his care. Finally, there is the option that the child be transferred to St Michael's Boys, Diego Martin, with suitable undertakings and conditions provided for his supervision and care. Then, my lords, I think I can ask you just to jump somewhat to paragraph 42, which evidences what the judge decided. He granted an order in the following terms, and it's quite a long order, but in terms of interim relief, it appears at 2774 at little 6, that as interim relief, A, the Children's Authority do provide to the court the name and location of a suitable community residence or home or residence for the accommodation of Brian during the pendency of these proceedings, and inform the court of such accommodation together with this assessment on affidavit to be filed and served. B, in default of them naming such a suitable accommodation, the parties attend court on the 3rd of September for further directions and order. C, the Children's Authority do conduct, 1, an assessment, and 2, another type of assessment. I don't think I need to read those. And then D, a conservatory order that the Commissioner of Prisons do release the intended claimant into the care of a suitable community residence or home or residence by the Children's Authority pursuant to paragraph A. So that was the paragraph I just read you about them providing the court with the name and location of a suitable residence. My Lord, we then go to the 4th of September 2015, page 2777. This is a short judgment when the matter came back before the learned judge, and in paragraph 1 he refers to his earlier judgment and explaining why interim relief was necessary, and that he left open the final direction. And then at 2, I've decided to give further directions in chambers without a hearing after reading the documents filed by the Children's Authority. We then go to paragraph 12, my lords, please, at 2780. From the evidence submitted by the Children's Authority, the St Michael's Home for Boys may be the preferred option, but with suitable undertakings to be determined after inquiry by this court. At this stage, however, the court does not have all the relevant information to make a decision. And then, my lords, I think we can go to paragraph 15. I would make, that's page 2781, forgive me. I would make a determination on a suitable accommodation upon receipt of all the information, as well as interrogating the representatives of the Children's Authority, etc. So, in short, the status quo was maintained. The order following that hearing, for your lordship's note, I don't think I need to take you to it given the time available, is at 7:09. Then we go to the 29th of September 2015 and a further hearing. My lords, at 2782 and following are the reasons of the learned judge in relation to this hearing. Could I just ask you to note paragraph 13 first at page 2789. The orders made by the court were not sought by the claimant. So in other words, what the learned judge was there acknowledging was that the quite sort of complicated and careful route he took and the orders I've been showing you were not things actually asked for by Brian, because as I showed you at the outset, Brian simply asked to be released to his mother by way of interim relief. My lord, the order made does not appear from the judgment, but is set out in the judgment of the Court of Appeal, because there was an appeal from the judge's orders, and that is at 2791. And one finds the order made at 2795. So actually you need to start at the bottom of 2794, the last two words, then on, and then moving to 2795, the 29th of September, that was the date of the judgment I just showed you. At the first case management conference, so that was the nature of the hearing, the judge made additional interim orders, which are the subject of this appeal. These orders, so far as is material to this appeal, were as follows, and I'm afraid, my lords, this is the only place I can find them. I don't think we have an order, a sealed order. And it is hereby ordered as followed that, and then one goes to page 2796 for the substance of the order, and you'll see that various orders, including for assessment and therapy and family therapy and a training program, were made. And at paragraph 3, that there should be collaboration to devise a treatment plan. and at 5, that the Children Authority and Parenting TT be permitted access to the premises of the Youth Training Centre. So no order had been made determining that he'd be put anywhere else, and he was still at the Youth Training Centre. One can see from that. Then, my lords, if you could just turn to paragraph 24 of this judgment on page 2807. The Court of Appeal said that, in our opinion, the trial judge was entitled to intervene as he initially did on the 20th of August, which I showed you, and so on. My lords, we then see at paragraph 45 on page 2814, it is, however, our view that thereafter the trial judge ought to have left it for the Children's Authority to independently act as it determined was necessary to fulfil its statutory duties, and so on. And in 48, it's in this context, and that was essentially in making the quite complex orders he made, that the interim orders of the 29th of September were altogether unwarranted. 49, nothing leading up to the making of the order of the 29th of September justified the court's continuing discovery, interrogation, and purported implementation of the assumed role and function of the Children's Authority. And at 50, as explained above in relation to the interim orders of the 20th of August and the 4th of September, so also in relation to the challenged interim order of the 29th of September, the trial judge overreached his jurisdiction and the scope of his powers, essentially, my lords, because I don't think I need to take you to the detail of it, for stepping in to the shoes or descending into the arena and not leaving it to the Children Authority to do as it saw fit, but seeking to impose his own views of what ought to be done by those various orders that I've shown you. My lords, then if I could just ask you to look finally at page 444, which is back in the judgment of Justice Cokeram. 444 at paragraph 31. The first part deals with Sasha, and then the last sentence deals with Brian. The date of this judgment is the 24th of May 2016. BS was remanded, so Brian was remanded to the St Michael's School for Boys, St Michael's, on 14th of April 2016 and is no longer at YTC. This was a development which took place after the court reserved judgment. My lord, that was a very long way of giving the best answer I can to the question, what happened to Brian? I'm afraid I can't give a clearer answer than that, but that demonstrates both what he sought, which was limited interim relief, the rather complicated relief that the judge in fact granted, which he had not asked for, the Court of Appeal accepting he was entitled to do so much, but not everything he did do. And then here, finally, recitation of the fact that on the 14th, he was remanded to St Michael's School for Boys. My lords, I'm sorry, but I can't give any clearer. My lord.
Mr. Stevens, I have two questions. First is this: is it accepted that St Michael's was a statutory community residence?
My lord, I'm sorry, but I don't know the answer. I don't know the answer to that.
The second is this: throughout the whole of this period, the Children Authority appears to have been discharging its statutory duties and functions under the legislation. With what exception? Is it accepted that their licensing function was disabled throughout this period by virtue of non-commencement of the relevant statutory provision?
Well, my lord, I certainly accept that only section 3.3 and not the other sections 1 and 2 were brought into effect by that proclamation. So I accept that it was not in force. What, of course, the judge refers to, and I can't give you the reference, is as he saw it, a period of grace which had been allowed by the, or provided for by the state for licensing and the like to take place. But I can't say that there is any particular evidence to support that, but that was the theory that the judge had. What I can't also say, but I will endeavour to find out, and if there is an answer, we'll let the board have it, but it may not be this afternoon, is whether or not that licensing machinery was brought into force, and if so, when.
Thank you. That was my final query. Yes.
Well, my lord, certainly. And likewise, your first query, which I've not been able to answer, I'm sorry. I will try and check the position, but that is the best that I can do in relation to Brian and the question of licensing for today's purposes. What I would say, though, is that two things. First of all, interim relief was granted. And secondly, and this is important, that the Court of Appeal clearly held that interim relief by way of Section 8 of the Judicial Review Act, and I'm going to show you that in a moment, was available. So an order of the sort that was made in favour of Sasha could have been made in favour of Brian, but no such order was in fact sought. That's not to say the judge didn't address his mind to finding a solution, and did, as you've seen, order that the Children Authority try and identify a suitable community residence. But it is important in considering due process of law, but more particularly protection of the law, to recognise that there was, sorry my lord, there seems to be a little feedback, that there was an available remedy. And my lord, this would be as good a moment as any just to make good that proposition. Can I start by asking you to look at the Court of Appeal's judgment in relation to Sasha's application for interim relief? That, my lords, is at page 2701. And my lords, to turn please to 2716 first. At 2716, in a footnote, rather small footnote, number 21, the Lordships will see Section 8 of the Judicial Review Act set out, and it provides, one, on an application for judicial review, the court may grant the following forms of relief: A, an order for mandamus, prohibition or certiorari, and then various other types of relief, which we're all very familiar with. Can I also just ask you to note that at subsection 4, on an application for judicial review, the court may award damages to the applicant if, and then there are two conditions: A, the applicant has included in the application a claim for damages arising from any matter, etc. And B, the court is satisfied that if the claim had been made in an action begun by the applicant at the time of making the applicant could have been awarded damages. And that's a conventional action, not a constitutional action. My lords, if you could then please turn to 2728 at paragraph 67. In any event, because this action is a mixed proceeding, injunctive interim relief could have been granted pursuant to Section 8 of the Judicial Review Act. I showed you that earlier. And then 68 at 2729, he had jurisdiction, that's the judge, to do so in this case by virtue of Section 8 of the Judicial Review Act, and also pursuant to Section 14 of the Constitution. My lord, if then I could ask you to look at the Court of Appeal below at 1228, My Lords, at paragraph 98, pertinent to Brian, one finds in the last sentence on the page, in our view, the appropriate order should have been for the state to provide a suitable community residence to accommodate Brian within a reasonable time. In other words, just the sort of order that was made in Sasha's case. And then at 1, 2, 3, 5, paragraph 111, in addition, no question has been raised that the magistrate did not constitute an independent and impartial tribunal. If the chief magistrate made an error of law in remanding the children to places which were not community residents, then the legal system provides avenues of redress in the form of judicial review or an appeal of the decision, but again, judicial review. My Lords, could you then please look finally at the I think I've shown it to you already. I don't need to take you back to it. I was going to ask you to look at the Judicial Committee's judgment in Sasha's case, where again there's a recitation of the Court of Appeal's reasoning by Lady Hale and acknowledgement that Section 8 of the Judicial Review Act enabled the court to fashion a remedy of the sort that was given to Sasha. Now, my Lord, the relevance of showing you all of that is really this, as a way in. I'm sorry, my Lord.
When you showed us the Privy Council, the earlier Privy Council case,
yes,
I formed the impression that the premise of the decision that interim relief was available was that there was an arguable infringement of constitutional rights.
Well, my Lord, the position was that it was conceded that there was an arguable case.
But you can't rely, can you, on the fact that interim relief is available on the premise that there's a potential infringement of constitutional rights, to argue that there is no infringement of constitutional rights.
Well, my Lord, two answers to that. The question of whether there was an infringement is fact and case specific. If one were to look at Sasha's case, and disregard for a moment Section 8 of the Judicial Review Act, the fact of the matter is, because there was an arguable case as to breach of constitutional rights, she did get an interim order which directed that she be accommodated in a community residence. Now, that on one view is sufficient in terms of the protection of the law or due process, whatever you want to call it, in meeting her complaint. But I see the point my Lord puts to me, but the answer, if that's not right, is that there was in any event a route open to her under Section 8 of the Judicial Review Act. And all she had to show for that purpose, to open that door, was what was found by the Court of Appeal and is not disputed by the state, namely that the remand was unlawful. And if the remand was unlawful on the basis that she should have been remanded to a community residence but wasn't, she was remanded to a prison, that opened the door to an order for mandamus under Section 8, and that would have been effective relief had she chose to do it. Now, the reason, my Lord, that I showed you Section 8, subsection 4 of the Judicial Review Act was just to make one quasi-forensic submission. It may be, I put it no higher than that, the reason that the constitutional route was taken rather than the judicial review route was because it was only under the constitutional route that damages could be awarded, because there was no ordinary action that could have been maintained. There's been no claim for false imprisonment, nor could there have been in the face of the Bail Act. And in those circumstances, if they were to get damages, the only way they could do that would be via the constitutional route. My Lord, that is somewhat hypothetical, I accept, but a possible explanation. But in answer to my Lord's question, there was an effective remedy by way of judicial review, as I've shown you. The fact that Sasha appears to have got it via the constitutional route is neither here nor there in those circumstances. And the fact that Brian did not ask for it, and neither of them fashioned their request for relief under Section 8, does not detract from the fact that there was, in my respectful submission, the machinery in place by which they could obtain an efficacious remedy via the courts. And my lords, this is very much my introduction to protection of the law, which I'll come on to deal with in a moment.
Can you confirm, Mr. Stevens, that Brian's failure to specifically ask for the interim relief, which was later granted to Sasha, itself would not, in public law proceedings, have precluded the court in any event from making that order?
No, I accept that. And
the judge tried to grant an order, but he ran into the sand, didn't he?
Well, the judge tried to grant the order. What he envisaged was that the Children Authority would identify a suitable location, and then his order provided that upon that happening, Brian be transferred. But he did run into the sand, my lord, and then he found himself making a lot of other very well-intentioned orders, which the Court of Appeal subsequently found to be less well-intentioned. But it is a feature of this case, and I do not in any way seek to belittle the fact that Brian was not detained in a community residence, but it is a feature of this case that whereas Sasha was detained in a women's prison, the regime to which Brian was subjected was rather different in the youth training centre. And one only has to look at the judge's judgment. One only has to look at the way things are set out in the Statement of Facts and Issues, for that matter. The more serious complaints in terms of the nature of the establishment and the regime, by far more serious, were made in Sasha's case. But my lord, yes, I do accept that.
Lord Burrows has a question, I think.
I'm so sorry, my lord.
Yes, if I may, in this discussion of effective remedy, might it not be said against you that whatever the position in terms of what might or might not have been possible under judicial review, there was a period in which each of these children was in a place where they should not have been, and that therefore the only effective remedy for that is an award of damages?
Well, my lord, they were for a period, but as
well, we're talking about, I mean, whatever the period is, one would need the clarification of the facts that you that you may still need to ascertain. But that's not our issue, is it? Our issue is, was there any period in which there was no effective remedy?
Well, my lord, they were where they should not have been for a period. I have to accept that, obviously. The fact of the matter is that recourse to the courts takes time, and it's a qualitative assessment in considering whether or not there has been an effective remedy and a sufficient remedy, as to how long that took and what form it took. And your lordships have seen that so far as Judicial Committee was concerned in Sasha's case, the matter was dealt with promptly. I accept it's not the case that one day she complained and the next day things were sorted out, but that in the real world and the way in which the judicial system works and has to work is an ideal rather than a practical reality. And my lord, one saw in contrast the position of Dr. Naidiki, I think it was, who waited 8 years and 1 day for the judgment of the court. Well, that was obviously an egregious and breach, an inordinate delay, for which there was no good reason. But what was happening here was that attempts were being made to put things right, even by the judge in Brian's case. They didn't unfortunately hit the target as he'd hoped, but attempts were being made to sort things out, and it's a question, I suppose, my lord, of just how timeous the relief needs to be considered a sufficient protection of the person who finds themselves in that position. My lord, had Brian made an application under Section 8 and it being dealt with at an early stage, as it could have been, given the number of hearings there were before Justice Cochran, there's no doubt that his position would have been ameliorated rather more quickly, just as Sasha's was. My Lord, I think for the moment, at any rate, and subject to those questions that, as you rightly say, may be relevant and I can't answer at the moment, that's as far as I can go in answering your Lordship's question. So, my Lord, in the hope that chronology, if you like, as to what happened and that explanation of the powers that were available to the court assist your Lordships, can I now move to protection of the law? Rather like due process, protection of the law, my lords, has been considered by the courts in Trinidad and Tobago and elsewhere, of course, in a number of cases. And if I may, I'd just like to show you one or two of those. The first is Attorney General of Trinidad and Tobago and MacLeod. And my lord, that is at 2328 bundle. It's again a judgment of Lord Diplock. The case concerned the question whether an act to amend a provision of the Constitution dealing with the circumstances in which a member of the House of Representatives, so the lower house, was required to vacate his seat was void. That question was answered in the negative, on the basis that on a proper construction of the Constitution, the relevant subsection was not one which was entrenched and could therefore only be amended by special majority, and so it could be amended. Lord Diplock nevertheless considered the reliance placed by Mr. MacLeod, the politician, on section 4B of the Constitution at 2336. Could I ask you to look at letter, just above letter H? No, my lord, I think in fact I can start just below letter H at the bottom of page 2336. In his originating motion, however, the only infringement of his fundamental rights that Mr. MacLeod alleged was his right to the protection of the law under section 4B of the Constitution. The law of which he claimed to have been deprived of the protection was section 54(3) of the Constitution, which he contended successfully in the Court of Appeal prohibited Parliament from passing the Amendment Act except by the majority specified in that subsection. This argument, although it was accepted by the Chief Justice and Justice of Appeal Kelsick in the Court of Appeal, is in their lordships' view fallacious. For Parliament to purport to make a law which is void under section 2 of the Constitution because of its inconsistency with the Constitution deprives no one of the protection of the law, so long as the judicial system of Trinidad and Tobago affords a procedure by which any person interested in establishing the invalidity of that purported law can obtain from the courts of justice, in which the plenitude of the judicial power of the state is vested, a declaration of its invalidity that will be binding on Parliament itself and also upon all persons attempting to act under or enforce the purported law. Access to a court of justice for that purpose is itself the protection of the law, to which all individuals are entitled under section 4B. Now, my lords, those observations, of course, were observations made in the context of a challenge to legislation which was alleged to be unconstitutional. Nevertheless, in my submission, by parity of reasoning or by analogy, access to the court in order to challenge the lawfulness of the orders of the Chief Magistrate remanding the appellants similarly satisfied the requirements of the protection of the law in my submission. And whilst the protection of the law, like due process, is not necessarily spelt out exhaustively in section 5(2) of the Constitution, and as Lord Diplock said in MacLeod, is better left to be considered on a case-by-case basis, and that's the bottom of the same page that I showed you earlier. The nature of the protection of the law has been considered in other cases, and one such case was Central Broadcasting Services and the Attorney General, and that's at 2339. In that case, the appellants who had applied unsuccessfully for a radio license alleged that they had been denied equality of treatment, contrary both to section 4B and 4D of the Constitution. Your Lordships will see that at paragraph 5 on page 2342. The section 4B, of course, providing for the protection of the law, and section 4D, providing for equal treatment from a public authority in the exercise of any functions. Lord Mance gave the judgment of the board, and in doing so, he corrected an assumption made in both courts below to the effect that the protection of the law was engaged at all. And he clarified the nature and scope of the right to the protection of the law. So, my lords, could you turn to paragraph 20, which is at 2347, letters D to E. The board has, however, one observation to make on the treatment in the courts below of the issue of inequality. In both courts, it was assumed that the unequal treatment which was established justified a declaration of breach both of section 4B and section 4D of the Constitution. The board does not consider this to be correct. Section 4D is the provision covering circumstances such as the present, so the grant of a license by a public authority, effectively. Section 4B is, in the board's view, directed to equal protection as a matter of law and in the courts. There is here no suggestion that either the law itself or its administration by the courts was discriminatory, but the established breach of section 4D against the Attorney General has lodged, against which the Attorney General has lodged no appeal, is by itself sufficient finding of discrimination. So, my lords, that's Lord Mance. I accept. My lord, yes.
Mr. Stevens, I was encouraged to take a look at the Bhagwan Eden case, on which Lord Mance founds for that proposition.
Yes.
And when I did so, I discovered that what Lord Carswell says in the relevant passage is that the appellant did not contend that he was deprived of the protection of the law. That really was just about all that was said about it.
Yes, well, my lord, I'm sorry that it's not in the bundle, and that makes it hard for me to. I obviously entirely accept what your lordship said. That makes it a little hard for me to respond. So, suffice it to say, my lord, I'm sorry. Suffice it to say, my lord, that I simply rely upon this, whilst accepting that it was not the point in issue in the case, in the sense that it didn't fall for detailed consideration. I accept that. I simply rely upon it.
Is it an obiter passage? That was my second question.
Yes, well, I think arguably it is, my lord. Yes. But what it is an authoritative obiter passage from none other than Lord Mance, who, as your lordship will know, was very well versed in the Westminster Model Constitutions. And my lord, he there is pointing to equal protection, both as a matter of law and in the courts. Now, I'm not going to be saying that it can't go any further than that, but that is the way it's approached. I'm sorry, my lord, you've had your hand up for a long time. I should have stopped.
No, you were quite right to answer. Lord Mance seems to have been focusing on a complaint about unequal treatment,
yes,
which is probably a different aspect of clause 4B. It's got two limbs to it.
Yes.
And the first is the right of the individual to equality before the law, and the second is to the protection of the law. He wasn't dealing with the sort of complaints that we're dealing with here. He was dealing with a question of equality, wasn't it?
Well, I accept that, and that's why, my lord, I said arguably, perhaps I shouldn't have included the word arguably, that it was obiter. I do accept that it is not a full or detailed consideration of what the protection of the law amounts to, but what it is a clear indication that Lord Mance at least thought this had to do with protection in the courts. And my lords, I rely on it for no more than that.
But he's talking about equality, equal treatment being protected in the court.
Well,
I'm not saying that.
Well, my lord, I'm not sure, my lord. Section 4B is, in the board's view, directed to equal protection as a matter of law. Now, that is in relation to equality, and in the courts is the way I read it, arguably, my lord, at least.
Right.
But Mr. Stevens, you still have, of course, the observation of Lord Diplock in MacLeod.
Yes.
But I wonder whether, having regard to a case like Meyer in the
My lord, I'm going to come.
West Indies, whether the fact things have moved on rather since then.
Well, my lord, I did acknowledge a moment ago that I was not going to suggest that things were fixed and that it could not go further, and I'm going to deal with Meyer in a moment.
Right.
But, can I trace the authorities just a little bit further first, with respect? Now, my lords, the next case that I was going to refer you to is one that my learned friend relies on in particular, Sam Maharaj, which you have at 2441. And this really was his way into the Meyer Leaders case. Now, my lord, forgive me while I just... Yes, my lord, it is 2441. Now, it's of course true that in that more recent case, Lord Kerr, giving the judgment of the board, noted both the expansive approach taken to the right to the protection of the law in two cases decided by the Caribbean Court of Justice. My lords, I hope I'll be forgiven for summarising it because you were taken to those paragraphs, by my learned friend. They're paragraphs 25 and 26 on 2449. So he noted that expansive or more expansive approach taken by the Caribbean Court of Justice in two cases. And further, he noted that whilst access to the courts is an important aspect of the constitutional protection provided for in Section 4B, it must be prompt and efficacious. And those observations are to be found most clearly in paragraphs 37 and 39 on 2453, the first of which you were likewise shown by Mr. Clayton. As to the latter, prompt and efficacious, for it to be effective, that observation it was unsurprising in the circumstances of the case because they were frankly extraordinary. The appellant waited 8 years and a day for judgment without any explanation whatsoever being offered for the inordinate delay. But apart from that, my lord, both the cases cited in Attorney General and Joseph and Boyce, which is the first of the Caribbean Court of Justice cases referred to by Lord Kerr, to demonstrate, as he categorized it, the wide scope of the protection of law, and the examples given by Lord Kerr himself in Sam Maharaj, as I'll endeavour to show you in a moment, of the wide-ranging interpretation of the protection of the law provision by the courts locally in Trinidad and Tobago, are all of a piece in my submission. They are all examples or instances of the denial of natural justice or procedural unfairness, which has been held to be a component of the protection of the law. Now, my lords, have the Attorney General of Barbados and Joseph and Boyce decision of the Caribbean Court of Justice at 2202. It's a very long decision, but the principal judgment was given by the President, Michael de la Bastide, and Justice Saunders. And could I just take you to paragraph 61 of that, which is at page, I think I gave you the page, 2202. The constitutions of both Jamaica and the Bahamas contain provisions which mirror exactly sections 11 to 24 of the Barbados Constitution. though the numbering of these sections differs from one constitution to another. And then there are a series of cases referred to. The first is the Jamaican case of Lewis, which was a case very much the same as Thomas and Baptiste, and the right of condemned men to consult petition international bodies before consideration of any petition for the a grant of mercy by the president on the recommendation of the local mercy committee, also called the Privy Council, confusingly. But the second was Ong, referred to at paragraph 62, and that too was a case involving natural justice, as one can see from between letters E and F. The third was Thomas and Baptiste itself, which I need say no more about, but involved, of course, the concept of procedural fairness, as the passage set out shows. And my lords, all of those cases, as one can see, were instances of the denial of natural justice or procedural unfairness. Similarly, if one goes back to Sam Maharaj, which is at 2441, I think. It starts at 2441, and one looks at 2450. I will come back to the Maya leaders case, my lord. 2450. Paragraph 27, Lord Kerr there says, there's no reason to suppose that the courts in Trinidad and Tobago would have adopted a different approach. To the contrary, courts in that country have consistently favoured a wide-ranging interpretation of the protection of the law provision. And he then goes on to refer to a number of cases. So starting in paragraph 28, for the most part, these cases have applied the decision of the board in Rees and Crane. And one can see 4 lines from the bottom of that paragraph before the quotation. Lord Slynn, who delivered the judgment of the board, said at 188G that the protection of the law provision in section 4B included the right to natural justice. Samaru was a school suspension case, and one can see 5 lines down in 29, the judge, who was Justice Jamadar, as he then was, stated at page 8 of his judgment that a suspended pupil should be informed of the reasons of his suspension and given the opportunity to make representations. And then after the quotation, implicit in the right to natural justice is the concept of fairness, the antithesis of which is arbitrariness. And then paragraph 31, Mohammed is a further example of acceptance that breach of the rules of natural justice constitutes a violation of the protection of the law provision. And 32, the board was not referred to a case in which the government of Trinidad and Tobago or any of its emanations or agencies had argued that the right to the protection of the law enshrined in section 4B did not comprehend a right to be treated fairly, or that it did not give rise to an obligation on the part of public bodies to observe the rules of natural justice. So, my lord, the extensions, if I can put it that way, or the extension of the protection of the law beyond mere access to the courts for a judicial determination of rights, in every one of the cases referred to, both by the President and Justice of Appeal Saunders in the first of the Caribbean Court of Justice cases, and every one of the examples given by Lord Kerr are examples of natural justice and procedural fairness being a fundamental aspect also of the protection of the law. And apart from the Maya leaders case, to which I'll come in a moment, there is nothing in any of the authorities that either side have put before you to suggest that, albeit it extends, as I hope I did accept, beyond mere access to the courts for a judicial determination, that the protection of the law goes anything like as far as Mr. Clayton suggests. Now, that of course, at the moment is without looking at the Maya leaders case. Now, my lords, I come therefore to that case, and you haven't been taken to it by. Sorry, my lord.
Just as a matter of principle, Mr. Stevens, if a law is enacted which is intended to provide a form of protection to a group of individuals, in this case children, and that form of protection is simply not provided, is that not squarely a case of lack of failure to provide protection of the law? I mean, just on the face of the provision.
Well, my lord, there may have been no compliance with that particular statutory mandate, and there wasn't in this case, and therefore there was an application by way of judicial review, which resulted in orders confirming the illegality of the remands. But that is one thing. The question whether the protection of the law in the constitutional sense extends to compliance with every statute mandating X, Y, or Z is another question with respect. And this is perhaps one has to look at this rather as Lord Hoffman did in relation to due process of law. There may be a broader sense in which protection obviously requires compliance with statutory provisions, and there's a machinery for ensuring that that happens via judicial review. But a narrower sense in which one gets to protection of the law in the constitutional sense. And it may be that when we look at the Meyer Leaders case, I can assist a little further in relation to that. But my answer with respect is that what the Constitution requires is that there is a way of seeking relief. And I accept that that has to be efficacious. And if there is, then that is satisfaction of the constitutional requirement that there be protection of the law.
Does your case depend on that? Suppose we were to find that there was not an efficacious form of relief. Would you then expect that there was in those circumstances a violation of the Constitution? Or do you have two alternative cases? One that there isn't because there's an efficacious form of relief, but the other that it doesn't matter anyway, because even if there's no effective relief, it's still not a constitutional breach.
Well, my lord, I think on the authority of Sam Maharaj, where Lord Kerr postulated that there may be cases where the right to the protection of the law can be fulfilled by the availability of an effective and prompt remedy provided by the courts. That's his paragraph 39, but went on to say that that's not necessarily always going to be the case. And I would be bound to accept that there could be a case where, if there was approaching it in the qualitative way that you have to, no reasonably efficacious, and by that I mean within a reasonable time, because the courts can't be expected to provide relief before they're asked to do so, and even when they're asked to do so, it takes some time to work through the courts. But if that process takes a reasonably speedy course, and the person's rights are thereby vindicated, that would amount to an efficacious remedy, in my respectful submission. Where it breaks down, as it did in Sam Maharaj's case, and he got nowhere for 8 years and a day, then one possibly can say, well, one clearly can say on the authority of that case that there was not an efficacious remedy in those circumstances. It all depends. If there is a route which can be taken, as there was in this case, and if it results in a satisfactory solution within a reasonable timescale, which can only be measured by an appreciation of how long it ought reasonably to take for the wheels of justice to work and for things to be sorted out, then in my submission that does amount to a satisfactory remedy, and there is no breach of the protection of the law in those circumstances. And the clear finding of the Court of Appeal.
Well, I appreciate you're making that submission, but you're also accepting the converse, are you? That if that were not the case, then you would be bound to concede that there was not protection of the law, if there were no efficacious and sufficiently tenuous remedy.
Well, my lord, I think, I mean, paragraph 37 of Sam Maharaj says this: access to the courts in order to challenge a claimed breach of an individual's legal rights is clearly an important aspect of the constitutional protection provided by section 4B. But for the protection to be effective, access to justice must be prompt and efficacious. Now, I think I have to accept on the authority of that there could be a situation in which, if the courts do not afford prompt and efficacious relief, there could be a breach. But that is not this case, with respect.
Thank you.
Does that mean that in every case where there's a failure to provide prompt and efficacious relief, there's a constitutional breach?
Well, my lord, it will all depend on the circumstances of the case.
Yes, thank you.
The nature of the breach, the nature of the relief sought, when it was sought, how long it did take, how long it should have taken, and so on. These are all questions of a degree, in my respectful submission, and therefore it's a qualitative assessment. But first and foremost, protection of the law requires access to the courts. That's the clear message that one gets from all of the earlier cases that I showed you. It is still what is said by Lord Kerr in Sam Maharaj, but that case contemplated a possibility where, if it's not prompt and efficacious, there could be a breach, and that much I do accept, but I don't accept for a moment that this is that case. Would my lord just give me one moment to confer with my junior in relation to one matter before I move on to the Maya Leaders case?
Yes, of course.
Thank you very much, my lord. My lord, thank you very much. Can I now come to the Maya Leaders case, which your lordship asked me about?
Yes.
You've not yet been shown it as such. You've only seen what is extracted from it in Sam Maharaj. It's at 2546 of your bundle. My lord, the decision of the Chief Justice at first instance in relation to this claim in relation to customary land rights is set out at paragraph 26 at 2560. Simply by way of background, the Chief Justice came to the conclusion that Maya customary tenure existed in all the Maya villages in the Toledo district, and that where it existed, it gave rise to collective and individual property rights within the meaning of sections 3D and 17 of the Belize Constitution. The learned Chief Justice issued the requested mandatory and injunctive relief, directing the government to develop a system to accord legal protection to Maya customary land tenure and refrain from any action which might prejudice the rights of the Maya. However, Chief Justice Conte failed to find any constitutional breach and refused to make an award of damages. My lords, then I think we can go to paragraph 27, simply to note the first sentence that the Court of Appeal was divided. And then in paragraph 28 and 29 appears a summary of the decision of the majority in the Court of Appeal. So the majority decision given by Justices of Appeal Morrison, Justice of Appeal Morrison, with whom Justice of Appeal Elaine agreed, dismissed the government's case that upon the assertion of Spanish sovereignty over the settlement, now known as Belize, in 1540, and in any event upon assertion of British sovereignty, the ancestors and inhabitants of the villages the claimants purport to represent did not occupy lands in the Toledo district, nor practice or enjoy customary land rights over those lands. So the government's case was rejected. And then I think I can move to paragraph 29. However, Justice of Appeal Morrison, with whom, as we've just seen, Justice of Appeal Elaine agreed, found that sections 3, 16, and 17 of the Constitution, interpreted in the light of decisions as Ong, Attorney General, and MacLeod, could not provide the basis for ordering the state to take affirmative action for the protection and furtherance of constitutional rights. He held that the mandatory order and injunctive relief issued against the government could not stand. Learned Justice of Appeal also considered that there was no evidence the Chief Justice had taken into account more general considerations in granting injunctive relief. It followed from this that the appellant's contention that award of damages were justified could not succeed. My Lord, if we could then go to paragraphs 38 onwards of the judgment, where the consideration of the question whether there was a breach of the right to the protection of the law begins. Section 3A is set out in terms that are familiar. Life, liberty, security of the person, and the protection of the law. I won't read it all. Paragraph 39, Section 3A has been traditionally understood as guaranteeing access to courts and tribunals which are independent and impartial. This is further underscored by the words of Section 6(7) of the Constitution, which is then set out. Paragraph 40, in delivering the majority judgment in the Court of Appeal, Justice Bill Morrison found that the notion of protection of the law spoke to the availability of processes for the vindication of rights rather than to substantive rights themselves. Appearing as it does in what is in fact a preamble to Part 2 of the Belize Constitution and the detailed elaboration of the fundamental rights and freedoms which it contains, the phrase protection of the law in Section 3A is, in my view, an assurance to persons in Belize of a continued right of access to the courts of Belize under a system of law that is fair, the declarations of the invalidity of executive or legislative action. We would respectfully disagree that this narrow interpretation is properly to be given the wide spectrum, the wide spectrum of rights entailed in Section 3A. Now, my lords, I think I can then probably go to paragraph 42. We wish to be clearly understood as affirming that the right to protection of the law does encompass access to and the enjoyment of the fundamental rules of natural justice, and then owing is cited. 43, similarly, an Attorney General of Trinidad and Tobago and MacLeod, and what I've shown you is referred to. And then in paragraph 44, but whilst we readily accept that access to independent and impartial courts or other judicial bodies is perhaps the most visible aspect of the right to protection of the law, we are of the opinion that this right goes well beyond the issue of access to judicial or quasi-judicial proceedings. In a lane, the High Court appears to have accepted that the right to protection of the law could in principle encompass an obligation on the state to make subsidiary legislation and to institute administrative arrangements to protect the right of municipal police officers to receive similar benefits as regular police officers. The Court of Appeal affirmed this decision, holding that equal protection was not limited to the right of access as set out in the MacLeod decision. This court, in Attorney General and Joseph and Boyce, Per de la Bastide v. Anne Saunders, JCPC, said that the right to the protection of the law is so broad and pervasive that it would be well nigh impossible to encapsulate in a section of the Constitution all the ways in which it may be invoked or can be infringed. Pausing there, my lords, they did say that, but with respect, the examples they gave were all instances of a breach of natural justice or a failure in proceedings, in fairness in proceedings. My lord, then, if I could take you to paragraph 47. I hope I'm not unfairly selecting what I'm taking you to. I think this is entirely representative of the case. The law is evidently in a state of evolution, but we make the following observations. The right to protection of the law is a multidimensional, broad and pervasive constitutional precept grounded in fundamental notions of justice and the rule of law. The right to protection of the law prohibits acts by the government which arbitrarily or unfairly deprive individuals of their basic constitutional rights to life, liberty, or property. It encompasses the right of every citizen of access to the courts and other judicial bodies established by law to prosecute and demand effective relief to remedy any breaches of their constitutional rights. However, the concept goes beyond such questions of access and includes the right of the citizen to be afforded adequate safeguards against irrationality, unreasonableness, fundamental unfairness, and arbitrary exercise of power. The right to protection of the law may, in appropriate cases, require the relevant organs of state to take positive action in order to secure and ensure the enjoyment of constitutional rights. Now, that pausing there is very important. It may go that far in order to require the state to take positive action to secure and ensure the enjoyment of basic constitutional rights. And as we'll see, the basic rights of the Mayan people were not recognized. And that's why relief in this case had to go that far. Reading on, in appropriate cases, the action or failure of the state may result in a breach of the right to the protection of the law, where the citizen has been denied rights of access and the procedural fairness demanded by natural justice, or where the citizen's rights have otherwise been frustrated because of government action or omission. There may be ample grounds for finding a breach of the protection of the law, for which damages may be an appropriate remedy. My Lords, then paragraph 51, please, at 2571. In the present case, the appellants allege that their right to protection of the law has been infringed by actions of the government in granting leases, licenses, permits and concessions that deprive the Maya people of the enjoyment of their rights, and in failing affirmatively to recognise and protect Maya customary land tenure, despite the affirmation of the existence of these rights in the Maya land rights case. The findings and recommendations of the Inter-American Court of Human Rights and the government's own admission of the existence of Maya customary rights in the 10-point agreement. And then, my Lord, moving to paragraph 57, that 2573, it is not disputed that the current system of Belizean land law does not extend protection to the individual's collective land rights which arise under the Maya system of customary land tenure. Despite being alerted to this deficiency as far back as 1998, when the Maya people first filed a petition with the Inter-American Commission of Human Rights, alleging a breach of the right to property as contained in the American Declaration, the system of Belizean land law remains unchanged. Whilst the complexities and intricacies involved in attempting to reconcile two competing systems of land tenure are readily understandable, the delay of the government in Belize in resolving the issues of indigenous title cannot go unchecked. And then, my Lord, just to finish, I think, paragraph 60, if I may, 2574, we emphasize that the obligation on the state necessarily follows from the recognition that Maya customary land tenure, a species of property rights not provided for in the current legal system of Belize, and that's important, my Lords, is protected under sections 3D and 17 of the Constitution. The concessions made by the government in the 10-point agreement and the consent order lead to the unavoidable conclusion that the existing property regime fails to adequately protect Maya interests in the land within Mayan villages, and that the claims based on adverse possession would not do full justice to the nature or extent of the customary land tenure rights of the Maya. In particular, the statutory regimes in the General Registry Act and the Registered Land Act fail to provide a mechanism for identifying, documenting and titling Maya customary property, as indeed it does for non-Maya customary land tenure. There has undoubtedly been a failure to recognise and protect Maya land rights, and this is one of the implied concessions in the consent order. My Lord, just for completeness, the consent order is set out in paragraph 9, which starts at page 2550, and the body of the order is at 2551. And you'll see, for example, in paragraph 3 that in order to achieve the objective of paragraph 2, the court accepts the undertaking of the government to, in consultation with the Maya people or their representatives, develop the legislative, administrative and other measures necessary to create an effective mechanism to identify and protect the property and other rights arising from Maya customary land tenure. And then further in paragraph 4, other specific measures are provided for. Now, my Lords, I said when reading paragraph 60 that it was important to bear in mind that the obligation on the state followed from the recognition that Maya customary land tenure, which was a species of property rights not provided for in the current legal system of Belize, and that there had been, at the end of that paragraph, undoubtedly a failure to recognise and protect Maya land rights. Now, my lords, the position, therefore, in the Maya leaders' case was that the villagers' land rights were not recognised under Belizean law, and nor was there any remedy to enforce and protect those rights other than by recourse to the Constitution itself. And for that reason, Section 3A of the Constitution was recourse to it was both necessary and apposite. And similarly, the government's undertakings that I've just shown you in paragraph 9 to adopt affirmative measures to identify and protect the Mayan villagers' property rights and develop necessary legislative, administrative, and/or other measures reflect the positive action that the protection of the law may require in an appropriate case where there's absolutely no provision under the law in Belize, in that case, to protect those land rights. Now, there was nothing with respect of that sort in the present case. The Children Act was clear, except it wasn't complied with, but it was clear in its provision. Access to the courts was available to the appellants, as I sought to demonstrate. And, if your lordships accept my submission, an effective remedy was available to them by way of judicial review, although in fact Sasha got it via the constitutional route. And for those reasons, no question of recourse to the Constitution arises in contradistinction to the position in the Mayan villagers' case. So, my lords, in those circumstances, I submit there was no breach of the appellant's right to the protection of the law. I do accept that in an appropriate case, as I think those are the words used in the judgment that I just read to you, parts of to you, it may be necessary to go further. It was in that case, and it's not in this case. My lords, that is my answer to the Maya leaders case, a very different case. It's a case in which more was required, but essentially what was required was recourse to the Constitution to recognise their rights, which were not otherwise recognised at all under law, and to give them an effective remedy. These children's rights were recognised. They weren't complied with because they weren't detained where they should have been detained. But they were recognised. That's what the Children Act was all about. And there was an effective remedy, which Sasha obtained and Brian could have obtained. So, my lords, whilst I accept in principle that sometimes the protection of the law may require more than what has been traditionally recognised as its scope, access to the courts, efficacious redress, and those requirements of natural justice, which all of those cases spoke to. It's not this case, and the Maya leaders case stands as a sole example, and for that reason is the only case that my learned friend can pray in aid. But he runs into the immediate problem that whereas in Belize there was nothing to protect their rights, and that's why the Constitution had to be reached for, there was and is in Trinidad and Tobago. My lords, unless there are any questions, if I could just be given a moment to confer with my learned junior. I'm conscious of the time. I may not need to trouble your lordships further.
Right, by all means, take a moment. I think there are one or two questions, but
Why
don't you consult for the moment?
Well, my lord, yes, thank you very much, my lord. My Lord, I'm very grateful. I was conscious that I had not been able to give you a reference, which my learned junior has found. In fact, he's found two. I submitted earlier that the judge had taken the view that in relation to licensing, there had effectively been a grace period allowed. The reference for your note is 535. Perhaps I could just refer you briefly to it. So it's paragraph 233 of the learned judge's judgment. 9 lines down. The question of whether the community residences meet the Children's Authority standards for licensing is an entirely different matter. It is clear Parliament had intended a grace period for community residences to come up to the level appropriate for the licensing by the Children's Authority. This does not mean that they are not community residences, and so on. And there is also a reference, which I completely overlooked, in the Court of Appeal's judgment at page 1227 in paragraph 94. The judge appears to have taken the view that the issue of licensing or suitability was not relevant to the Chief Magistrate's decision as to where to remand the children. The law requires that children be remanded to a community residence. The issue of licensing was a matter to be determined by the authority, and Parliament had clearly intended a grace period to allow the residences to come up to an appropriate standard, at which time the authority would consider the grant of licenses. So what the learned judge appears to have done, my Lord, and the Court of Appeal appears to have endorsed, is to have read into the fact that those sections were not proclaimed an intention on the part of Parliament for that period, or a period, because obviously it's not specific, to be allowed. Now, that doesn't answer my Lord Sir Bernard's question as to when in fact licensing kicked in, and I will endeavour to provide that answer, but I can't, I'm afraid, do so now. I'm sorry, my Lord. There were some questions. I wasn't seeking to avoid the questions, but
you're not going to avoid them. Don't worry.
No.
My Lord Leggett first of all, and then Sir Bernard.
Of course.
In terms of effective remedy, Mr. Stevens, it's not just the position, is it, that they didn't get to go to a community residence for 3 or 6 or 9 months, however you measure it. This is going back to what Burroughs was raising, really. It's that they were sent incarcerated wrongly in an adult prison. And the fact that it took 3 or 6 or 9 months before they were fished out of there isn't an effective remedy, is it, for the time they spent there? Unless they get damages, they get no remedy for them.
But Lord, that I think begs the question of whether there was a constitutional breach. I mean, if there was no breach for the reasons I've submitted of the due process requirement or the protection of the law requirement, then there's no damages on that score. And my Lord, they have, of course, not pursued their complaint under section 5.2c of cruel or unusual treatment, which I accept of itself, had they pursued it and had they succeeded in it, might ground damages on the basis that the conditions in which the regime and the conditions was such that they should get damages. But if there's no breach, there's no damages, my Lord.
Now, I wasn't begging the question with respect to supposing a breach. I was founding simply on the unlawfulness of the fact there was a breach of the legislation, which says you shall not be sent to an adult prison. And suggesting to you that breach there is no effective remedy for the time they spent there, unless they can get damages, which they can only get by it being a constitutional breach.
Well, my Lord, that of course assumes that, with respect, that there should be an award of damages for non-compliance with a mandatory order in a statute. There are plenty of instances in which statutes require public authorities to do X or Y or Z, and it won't be in every case that damages can be claimed.
No. Thank you.
Mr. Bernard.
Mr. Stevens, could I just clarify one aspect of your submission regarding Section 5 of the Constitution,
Yes, my lord.
You drew attention to the interplay between Section 5 and Section 4,
Yes.
and you submitted that Section 4 informs and illuminates the content. I'm sorry, Section 5 informs and illuminates the content and scope of Section 4.
Yes.
Now, I was just trying to make a distinction, if there is one, between may thus illuminate, depending on the context, and may not illuminate, depending on the context, for the reason that Section 5 is a very clear affirmation of the supremacy of the Constitution in the Trinidad and Tobago legal system. And by way of reinforcing that, it prohibits Parliament from making any law which is in breach of the Constitution. That's really it in a sentence. There's no parliamentary conduct in the equation before the board. So to what extent does Section 5 assist us in the context which we are considering?
Would my lord just give me one moment to turn up an authority in the hope that it will assist?
The relevant page is 2017 for your assistance. That's where the Constitution is reproduced.
I've got that open, my lord. I was actually going to look at one of the authorities in the bundle. If your lordship would just give me one moment. My lord, may I just mute myself so that I can confer once more before answering the question? I'm grateful. My lord, it's curiously phrased in one sense, bearing in mind what I'm about to submit, Section 5. But if your lordship could look again at the case of Thornhill, and specifically at page 2631, at letter F, Lord Diplock explained that Section 2 goes on to give us particular examples of treatment of an individual by the executive or the judiciary. Now, my lord, that is the way, in other cases as well that are not in the bundle, I'm afraid, Section 5 has been understood, not as being limited to Parliament, my lord. And it's for that reason that instances, for example, of cruel or unusual treatment have on occasion given rise to damages, where, for example, somebody's been incarcerated in a way that infringes that provision, because that is obviously executive action that's being complained about. So, my lord, it extends further than it appears, is my answer to the question with respect. And indeed, it only makes sense if it extends to executive action as well. My lord, unless there is anything further with which I can assist the board, those are my submissions, and I'm sorry I've overrun my time a little.
Not at all. That was our fault. Thank you, Mr. Stevens. We're grateful. Mr. Clayton. You're muted, Mr. Clayton. Sorry.
So, I am so sorry. I begin with two factual matters. First, St. Michael's was never a community residence. Second, we have, in the interval of time, checked up what the position is about the Children's Authority licensing. It still is unproclaimed. It has no role in the licensing. Now, can I begin our submissions by making this point? In our respectful submission, it is crucial to dealing with the facts of this case. For what's crucial to it is my lord's view on how one characterizes the evidence of Ms. Boudram, the permanent secretary. This, with great respect to my friend, is not a case where we're saying every breach of statute sounds in constitutional rights. What we're dealing with, and I make no bones about it, is a failure by the executive to give effect to the legislation. That is the case on the facts. Second point I want to make is it's important when looking at the litigation this case is encouraged on the way through, particularly the interim litigation, to realize that we're at a different point in time. My lords are now looking at the position after the event, after all that has happened, and are being invited to hold that sections 4A and sections 4B are both breached. And that's a different question from the interim hearings. We nevertheless submit that in looking at the approach that was taken, bar the position at the very end, which I can come to, of the Court of Appeal, is that in reality, or in substance, a point I'm going to come back to, in substance, the courts gave primacy to the Bail Act and attached little or no weight to sections 54 and 60. Now, that's quite important in terms of the effectiveness of the remedy. And in our submission, section 54 and section 60 having been brought into effect, and my lords will remember there are three aspects to that, it is no answer to say, as the respondents contend, well, we couldn't, the Bail Act is predominant. In fact, the reality is both pieces of legislation are of equivalent status. And that's quite important to appreciate. There's no distinction to be made between the Bail Act and the other one, which is why we had the wild goose chase of trying to reconcile the two statutory provisions. The next point I want to make, which in our submission is very important in terms of appreciating the nature of the case my lords are invited to consider, is the principles of constitutional interpretation, to which I referred to Lord Bingham and Ray's, that it is to be broad, purposive, and in line with modern conditions. The first point I want to make in relation to that is the failure to accord children their rights under the Children's Act by virtue of section 54 and 60 is a paradigm example of a failure to give effect to modern conditions, the worse in our submission because it's pretty tolerable. I think it may be common ground that it was introduced and implemented to give effect to the UN Convention on the Rights of Children. The second point about modern conditions is that, of course, because it's broad, purposive, and expansive, the nature of rights change over time. My Lord Jones, forgive me, pointed out that many of the cases to which my learned friend referred predated the 2016 Maharaj case on equal protection of law. And with great respect, I'll deal later with how my friend seeks to get round it. That's the position, but it is also a striking feature of this case, if I may respectfully speak so, that we have been taken to some fairly ancient Privy Council cases on due process of law too. Now, things change over time, and I'm going to make a particular submission in relation to that in a minute. The next point I want to deal with is an assertion, and it's no more, that Section 4A is simply concerned with the rules of natural justice. I accept that the rules of natural justice are referred to in the older cases, but there's actually no submission which is to this effect, that fairness is restricted to the rules of natural justice. In our submission, and taking the point on the chin, that fairness is the touchstone in respect of, Section 4A, we submit it is fundamentally unfair where a court fails to perform its core function because it's disabled from doing so, of applying the relevant statute. That's what this case is actually about. It couldn't do it. And it couldn't do it because of the executive inaction in giving it the tools to do it. But in our submission, it must be unfair, forgive me, to suggest that where a court is disabled from performing its core functions, that comes within the scope of Section 4A. My friend then makes a number of submissions about interim relief, the way that was dealt with, and in pursuit of his assertions that this case is really about access to the court. The first point, but an important one in our submission, is the legislation came into effect on the 18th of May, 2015, at the government's own choice. It needn't have done that, it chose to. And in our submission, that's the relevant date one has to begin from. The next point I want to make is that as I may have misunderstood this, but what appeared to be submitted was the applications for interim relief somehow satisfied the requirement of access to the court. Two separate points to make about that. The first is, if I may say so, that is a striking example of lifting oneself up by one's bootstraps. Here it's said that because the interim court took an interim provisional view about the constitutional rights, that provided access to the court. That is a novel submission, and in our submission without substance. The second point we would make about it is that in any event, this isn't a case where the access to the court achieved very much, and that's not a criticism, subject to the point about the Court of Appeal on the 18th of, forgive me, I think it's the 18th of December. But until that point, 6 months had taken place, that it provided little protection or anything else to Sasha, who was virtually at her 18th birthday. I think she became 18 within weeks of the Court of Appeal judgment. Nor did it provide much assistance to Brian either. So we, in our submission in relation solely to the access to justice point, would submit that it wasn't efficacious, it wasn't effective, and therefore it doesn't avail the respondents in any respect. I next want to turn to our claim under the equal protection case. Like the Section 4A case, in our respectful circumstances, the scope of this right has to be understood in the particular circumstances of the case. And the particular circumstances of this case are the executive failed to do anything before the 18th of May, and it should have done. The next point I want to make about that is that if one looks at the carefully at the Belize Leaders case, the Belize Leaders case made it clear that we're dealing with a protean right, which scope is at present undefined, but in any event included inaction by the executive, precisely the complaint we make in this case. Inaction by the executive to give effect to legislation, which, but I don't want to sound pompous about it, but that with respect is a pretty serious and unusual, this is a one-off case, frankly, one would hope, but a pretty striking case at that. And we focus not on the court access, the access to the court, but on the inaction of the executive, and we're perfectly entitled to do that in the light of the Maharaj case and the specific decision the board took through Lord Kerr, that to have regard to the local jurisprudence. And it's obviously the Caribbean Court of Justice is a court of equivalent status, and there have been significant movements in that direction. The next point I want to deal with is this one. My friend sought to distinguish the Belize Alliance case on the basis that, as I understood it, perhaps wrongly, that indigenous rights were not recognized by Belize law. And he says, well, that wasn't the position here. Well, with respect, that is a submission which is pure formalism. It's formalism over substance. In substance, the claimants could not get any practical or enforceable relief by going to court. The suggestion, by the way, that they could have got mandamus is with respect, A, a final remedy, and B, fanciful. But in my experience, which is now too long, the number of cases that courts would grant mandamus are minimal. And I say that with some, that doesn't happen very often. And certainly doesn't happen in Trinidad either. But in our submission, it comes to this. The distinction made about the Belize Alliance case, it epitomizes, and I say this with great respect, because I appreciate the skill with which the case has been presented on the other side, that it epitomizes the way in which the respondents have focused on formalistic distinctions to evade problems about substance. And in substance, this is a case about the executive failing to do that which it is required to do in any constitutional democracy, which is to give effect to legislation because Parliament has spoken, and they've sought refuge from relying or even addressing any of that by saying, well, you could have, you got relief from the court who couldn't do anything because Section 54 or 60 were not in effect. My lords, unless I can assist you further, those are our submissions.
Thank you, Mr. Clayton. We'll just see if there are any questions for you. Doesn't look like it. Thank you very much. Well, we're very grateful to you, Mr. Clayton and Mr. Stevens, for your submissions. We're also grateful to those sitting just, I suspect, out of view, just out of range. I see one appearing momentarily for their support. We've been particularly assisted by the written cases, which were very helpful.
Thank you very much, my
for
lord.
all submissions. We will now take time to consider our judgment, and we will deliver them in due course. Thank you all very much. Court is now adjourned.